Well, hello and welcome to my Fireside chat video where I'm discussing the court involved attachment pathology with family law attorneys. So, this is my consultation segment to family law attorneys. Perhaps your client asks you to watch this segment, or perhaps you've located me on your own. And this is what I would say in initial few minutes to a forensics to a family law attorney regarding the case and the custody conflict that they're adopting. The field is changing in the family courts. Forensic psychology is a failed experiment. These forensic custody evaluations, you may be familiar with them, they're really bad. They don't solve anything. They're very expensive, take a long time, and they're on their way out as a failed model of service delivery. And we're going to be returning to court involved clinical psychology, diagnosis, and treatment. That's going to provide the court with an accurate diagnosis of what the pathology is that the court can then rely on it for decision making. Custody decisions are the court's decisions, they're not for the psychologists. Psychologists focus on pathology. The pathology of concern here is child abuse and spousal abuse using the child as a weapon. But the child abuse is the one that takes precedence because that child's life hangs in the balance of the court's decision in this situation. So the issue in the family courts is about treatment, not custody. The custody issue that you're being engaged around is a false issue. It's a symptom of the pathology, and it's a symptom feature specifically of the spousal abuse pathology. That the legal system, that you and the court and the judge are being manipulated as a weapon of spousal abuse by a narcissistic, borderline dark personality parent, one of the most manipulative humans on the planet. And they're manipulating the court legal system to inflict spousal, emotional, psychological, and financial abuse on the targeted parent. The problem in the family courts is an attachment pathology. It's a problem in the love and bonding system of the brain. That's the attachment system. The child is rejecting a parent. And a pathology, the attachment pathology, is a treatment issue, not a custody issue. And so we need to get this treated, whatever the problem is, we need to get it treated and resolved so that the child can have a normal range childhood. And so the question becomes whether the targeted parent is abusing the child. And if they are, that becomes a treatment issue. We put it on a treatment plan and stop the child abuse. Or whether the allied parent is abusing the child, which, if they are, that's a treatment issue that we put it on a treatment plan and fix the child abuse. But either way, we wind up at a treatment issue. And so the differing orientation that's coming to the family courts is a different legal argument to the court. Prior to this, you only had one choice. That was a forensic custody evaluation. You kind of go through your rotes where you know how to request that and you know how it was going to be 6 to 9 months, and then it comes back and it doesn't really answer anything, and everybody fights about it. And that's the previous model. The new argument and then to present to the court and the new approach will be not forensic but clinical. We need a treatment plan to fix the problem, whatever the problem is. Diagnosis guides treatment. Treatment for cancer is different than the treatment for diabetes. And so we need a diagnosis. Ultimately, though, we need a treatment plan. So don't get stuck on the assessment or diagnosis. We can get an assessment without a diagnosis. Here's your custody evaluation. We can get a diagnosis without a treatment plan. And we need a treatment plan, just not what the problem is. But if you go for a treatment plan, if that's your goal and that's your request from the court is to get a written treatment plan that the court can look at and everybody agrees to, then you will get a diagnosis because diagnosis guides treatment, and you'll have to get an assessment for the diagnosis. And so you get all three that way. But it's an idea switch away from custody, which is what this seems to be fighting about. And that, no, it's not. It's actually because it's going into the wrong system. The pathological parent is driving this into the legal system to solve a pathology problem because they can manipulate the legal system for their spousal abuse. It takes so long, it's so expensive, all these things. This is a pathology. It needs to go into the healthcare system. It needs to be solved in the healthcare. So we need to get it back out to that place. The in the legal system, what I would suggest is some self-reflective insight into your role in the situation, because this is child abuse, and the only cause of severe attachment pathology, a child rejecting a parent, is child abuse by one parent or the other. And so the question for the legal system and for all the members of the legal system, the family law attorneys and the judges, is whether the legal system, or you, being manipulated to become an instrument of child abuse and an instrument of spousal abuse using the child as a weapon, and by a narcissistic, borderline, dark personality parent. That when potential child abuse is a considered diagnosis, or when that's the issue, that the involved attorneys should not be using their knowledge of their craft in the furtherance of the child abuse. So if you apply your craft and get delays and convince the judge that not to get an assessment, or do all these things through the knowledge of, and skills of an attorney, you are acting in the furtherance of child abuse by your client. And that becomes a problem when attorneys begin to participate in the child abuse. The other feature about child abuse as an issue in the family courts is that attorneys are officers of the court and should not be using their professional art to conceal child abuse or mislead the court. That's a problem. When attorneys are concealing the child abuse or um, misleading the court about, or and using their craft to be able to do that. The third thing for some additional self-reflection within the legal community, and I heard this first raised by an attorney who was on a panel I was presenting on, that the zealous advocate role for attorneys is not appropriate for the family courts when child abuse is a considered issue. When child abuse is an issue, everyone needs to be working towards the protection of the child and getting an accurate diagnosis from one parent or the other. Both attorneys and the court should all be coming together to get a single accurate diagnosis. And we don't care which party it is. We just need that diagnosis of which party it is so we can protect the child. So the attorneys need to stay relatively neutral toward that goal of getting that accurate. Now, you can argue about whether it's an accurate diagnosis. You can argue about who conducts it. You can argue about a lot of stuff. But let's stop arguing about getting an accurate diagnosis. And let's make sure we get an accurate one so that the court can rely on it. We know we can protect the child. Diagnosis guides treatment. And this is an interesting understanding about the problem in forensic psychology generally, and what needs to happen relative to the psychology people. The diagnosis guides treatment, and treatment is our remedy. So your remedies are our treatments. And the treatment for cancer is different than the treatment for diabetes. So don't rush to remedy too quickly. Don't rush to treatment. Whoa, whoa, whoa. What's the diagnosis first? Are we treating cancer or diabetes? And so get that established first. And so these words mean the same thing. So we must first diagnose what the pathology is before we know how to treat it. We must first identify what the problem is before we know how to fix it. So diagnosis means identify, pathology means problem, treatment, fix it. And you can use all those words interchangeably. And so if you're making an argument to the court, just say the pathological parent's going to want to move this into some sort of custody decision. And you just say, whoa, let's wait on the custody decision for a little bit. Let's move this out and get an accurate diagnosis of the problem. But, Your Honor, we first need to identify what the problem is before we'll know how to fix it. So let's go out and get an accurate diagnosis, and then we'll know what the treatment plan will be. And I think that's a reasonable and rational argument So you put custody on hold for a little bit and get that accurate diagnosis first. And the one of the ways to conceptualize this is by analogy to the legal system. That the legal and the healthcare system are two parallel systems built on the same structure. And so at the top of the legal system is your judge. Over in the healthcare system, it's the doctor. The judges and the legal system has trials and to collect their evidence. The doctors have their clinical interviews and we collect our symptom evidence. Then the legal system applies the statutes to the evidence, and the healthcare doctors apply the diagnostic criteria to the symptom evidence. The judges render their verdict, the doctors make their diagnosis, the judges decide on remedy based on the verdict, and the doctors decide on treatment based on the diagnosis. So it's exactly the same structure in the two systems. Now, here's what's happening in the mental health system with the forensic psychologists, that essentially the doctors are conducting these forensic custody evaluations, the clinical interviews, but they're not rendering a diagnosis, which is like a court that has a trial but doesn't give a verdict. And instead, the forensic psychologists start making recommendations for what to do. So they go all the way down to, but they haven't applied the diagnostic criteria to the symptom evidence and have not rendered a diagnosis, which is as insane as a legal system that would hold a trial but not apply laws to the evidence and not render a verdict, but would then go to straight to remedy somehow. That's just extraordinarily problematic. And you can hopefully see the kind of thought disordered process in that we need to go back and first, get a diagnosis before starting treatment. It's like the legal system, get a verdict before you decide on remedy. Total sense. So that's the legal argument. Let's first get a diagnosis and then the treatment plan out of the doctors. And then we can decide what to do on custody and how to move forward on things. So first, apply the diagnostic criteria to the symptom evidence obtained in the clinical interviews and determine the diagnosis. Then decide on treatment based on the diagnosis. Similar legal system. First, apply the legal statutes to the evidence obtained in trial and determine the verdict. Then decide on the remedy based on the verdict. So that's the situation moving forward. I want to point out, though, that the healthcare system, us, the doctors, have been failing. We've been failing the children, failing the parents, and failing the courts. And we have obligations. So in addition to your role in advocating for your client in the legal system and with the court, we'll need to get higher quality mental health services for the family, for your client, and for the court's decision making. And the mental health system has obligations, and we're failing in those obligations. The doctors are. And the forensic psychology in the family courts needs to end. It is disabling the mental health system response to the pathology in the family courts. And so we need to move that away so that the mental health system response can reactivate and take care of the pathology, diagnosis, and treatment. And clinical psychology needs to return and needs to provide the court with an accurate information that the court can rely on for its decision making surrounding the child. So with that, I'm going to close off my introductory discussion with family law attorneys regarding a different approach and orientation. Your client may be familiar with my work and familiar with my advocacy for this approach, healthcare approach. Something to understand about forensic custody evaluations: they were an experiment. They have no history that they're anchored in. There was no thing called a forensic custody evaluation prior to the 1980s. Healthcare, diagnosis and treatment, clinical psychology goes back all the way into history, all the way back to the first doctors ever, in the tribal society. Diagnosis guides treatment. You're being possessed by a demon and your treatment is this potion. It's as old as healthcare. Diagnosis guides treatment. And that's what we need to get back to. We need to get back to the doctors, and the doctors need to step up and start doing our obligations. Forensic psychology needs to move aside, and clinical psychology needs to return to court-involved practice. So with that, good luck and take care. And I'm available for consultation to you. I hold general public consults the first week of every month. So if you want to talk to me or want to get through your client or something like that, I'm always available to provide some consultation. And by the way, I'm a full service psychologist. So if it's about autism or ADHD or any area of psychology, I can provide